This is one of the unfortunate case where my lord has dismissed the matter for default on 8th.
Yes.
This is a change brief. I got the change on that day.
What you filed an application?
We are filing an application.
File it. Yes.
Only one request. Let the file be not sent to the department. So that we'll be filing the application today. Let it appear Wednesday or
file it. Tell us.
Yes. Lordship.
Yes.
Lordship for inclusion.
Give.
Hearing matter.
Give. Yes. Call.
Item number 1.
State. First time it is coming.
Appearance and file before the lord the pad.
What is the issue?
Lord, for payment of lord family pension to the unmarried daughter. Was lord in the PLR office working as lord he retired.
Family pension of the unmarried daughter.
Unmarried daughter.
What is the date of unfortunate demise of the father?
Father demise lord. Father died lord 9/9/2004.
Huh?
9/9/2004.
9/9/2004.
That was mother was there. Lord mother also lord died lord 7th of June 2012. Then I have applied lord there time lord I have but I'm knowing the same. Where previously lord he did not know the same. After lord lord his her lord associates lord requested him lord he will get the pension. Then he says he applied. Applied lord in 2024 she applied. Page 32 lord. That the same is forwarded to the lord. The same is forwarded. Page lord 35 lord. It has been forwarded to the lord BLRO lord. It has been forwarded by the SDO to the BLRO. Lord, that time lord SDO of Puromindapur lord Tomlu Puromindapur has forwarded the same page 36 to the ADM LR Paschim Medinipur because he was previously attached with the Paschim Medinipur land department. Page 36 lord. Lord may direct the lord authority lord to consider it there whether she no order has been passed till date. Page 37 also lord. ADM of Puromindapur has forwarded the same to the lord ADM Paschim Medinipur. Page 37. This is the last communication lord.
Yeah. You've been sent to the LB. Yes. After 12 years.
Last communication, my lord, page 37.
After 12 years.
But my lord, because she was the my lord, my lord, daughter of my lord, remotest village.
Hmm?
She was living in remotest village, Puro Midnapur. She was remotest village in Puro Midnapur.
Where she has stated this in the OA? What has she stated in the OA? Why she has filed after 12 years?
Yes, he has settled, my lord. He did not.
So please read from the OA.
She did not know, my lord, his application.
Please read from the OA. Don't just make submission.
No, my lord, page 32 is the application.
Huh?
His
Please read from the OA what she has said. Why she has approached after 12 years. You cannot make up a reason. It is for the petitioner to state that. Where is it stated? Any document, any paragraph in the OA. One document you have a next which I cannot understand. This one. Filing after.
There is no such specific requirement.
Then how you can say?
Lord, his application is there.
How you can say, sir? We are
Lord,
asking.
his application is there. Application.
We are not on that. You are making so many submissions. We don't know when there is no pleading. How you can say?
Kindly allow me to submit, my lord. Your lordship, my lord, she is the my lord, daughter, my lord, she is living in my lord, very remotest village.
You cannot say this, sir. You page 32 is her application which she has submitted before the authority.
Yes.
She has said nothing.
Yes, she has said.
Please read what she has said. Why she is filing after 12 years.
আমার কোনো উপায় নেই, my lord, আমি মহিলা বিধায় বিভিন্ন অফিসে খোঁজ খবর করার কারণে অজ্ঞতা হেতু আবেদনের কাল বিলম্ব হইল।
What is it?
My lord, last line, my lord. আমি মহিলা বিধায় বিভিন্ন অফিসে খোঁজ খবর করার কারণে অজ্ঞতা হেতু আবেদন কাল বিলম্ব হইল। অতএব প্রার্থনা যে আমি অবিবাহিত কন্যা
12 years. 12 years.
my lord, that will not-
12 years. It's not 1 or 2 years
my lord,
that I am living in a remote place.
we are also living remote film laws. So many persons will come
No
to
case
us,
is
Lord,
made out.
after knowing the same from the relatives or some other
Sorry.
persons, my lord.
No case is made out. We do not find any reason.
My lord, your lordship may concept, my lord, because my lord, very pension matter, my lord.
Yes.
Your lordship, my lord,
That does not
I-
mean that whenever you want, you can come.
I submitted, my lord, my lord, on my daughter, my lord, well, not so, she is not retired, or
We
not,
don't-
not so retired person.
He must be
Your
25, 26 years at least of
Your
age.
lordship knows very well, my lord, my lord, the position of the my lord, remote, my lord, my lord, unmarried daughter or the widow daughter in the remotest village, my lord. We know that, my lord.
Sir, it is not so remote that it will take 12 years to approach the authority. We don't know how remote you are saying that it takes 12 years. In a remote place, we can understand 1 or 2 years it will take to organize things, 6 months, 8 months, 1 year, 2 years, 12 years.
My lord,
Plea of remote. How remote? Where is she living? Where she is living?
she is living, my lord.
Medinipur. It is so remote that it will take her 12 years to approach the authority.
My lord, we can
Kind of submission you are making.
assess that year. But Lord, so many persons are there, Lord, even till that, Lord, we can say, Lord, I can place your Lord, some cases. Even till that, Lord, 70 years old, Lord, they do not know what to do. Lord, to invest a pension. Already they are.
What the father was doing, which post he was working on?
He was working Pescar, Lord, in BLR office.
Huh?
BLR office.
As?
Pescar. Lord, I'm Lord, we request your Lordship, Lord.
There was no urgency. Obviously, there was no urgency.
Consider them.
There was no financial problem. Otherwise, you would not have waited 12 years.
Lord, let the authority, Lord, decide whether, Lord, they are, he is entitled.
You pursue your, we are not going to direct at such a belated stage. We can say you pursue it. Nothing more. In absence of state, we will not direct.
Already, Lord, that's the matter. I'm Lord, I say that state is not there. State is not there.
So you, where is your representation? You pursue it.
Page, Lord, that is, Lord, I have seen, Lord, page 32.
Pursue it, yes. Heard the learned counsel.
Item number 2.
I appeal to respondent number 2, 3, and 4.
Private respondent.
No, my lord, these are the staff selection commission. There are other private respondents are there, but pro forma respondents.
This matter relates to the selection process for the post of Group B. Advertisement dated 1st July 2018. Kindly come to the advertisement first, madam. Advertisement is at page
So what happened? Just tell us, give us a brief outline.
2018 advertisement. Subsequently, written test was held. We participated in the written examination. We succeeded in the written examination. Subsequently, we appeared in the interview process. After interview, merit list was published. That was not the merit list, only containing the name and roll number of the candidates, without detailing the marks and category. Now, my lord, in
So that was a result. That was not the merit list.
merit list. On the basis of that, appointment were given.
When that result was declared? When?
Declared result were declared in the 18th August 2018.
So in the same year.
Same year. Immediately thereafter, in the January 2019, we filed the original application before the tribunal. Seeking, our challenge is that there is a violation of the condition laid down in the advertisement and reservation of the violation of reservation policy, and also ratio which is mentioned in the advertisement that has not been maintained. In the original application, affidavit has already been exchanged between the parties. I'll kindly come to the advertisement part, which is at page
So unsuccessfully participated and then challenged.
Waitlisted. Subsequently, what has happened after filing the original application during the course of exchange of affidavit, the Group D recruitment board published a list of waitlisted candidates. In the waitlisted category, our names are featured.
So you don't want the benefit of the wait list.
No. What has happened? Subsequently, twice they published a notification reducing the cutoff. And in the notification, the option was there is non-availability of appropriate proper candidate. That's why we are going to revise the cutoff. Cutoff has already been revised. Then subsequently,
No, so there are two aspects. One is you participated till that date, you were not selected.
not selected but waitlisted.
Oh, no, you said after filing the OA you were.
Yes,
So
absolutely.
till that time you were not selected. After having unsuccessfully participated, you have challenged the recruitment process for some infirmities. Subsequently, you come to know that you are a beneficiary of the recruitment process because you are waitlisted. Now, the issue is whether you want to challenge the terms and conditions or you want to proceed after the result of waitlist.
What has happened when
You have to decide that first.
no. When they revise the reduce the cutoff, even we are not called for interview.
Therefore, we are saying there are two aspects. One is prior to declaration of your position in a wait list. There is one position, there is one circumstance after your declaration of position in the wait list. After wait list, your challenge to the recruitment process, can it survive?
Well, absolutely,
Or you will be concerned about how to operate the wait list, whether it is being operated to your detriment or not.
because there are challenge in respect of that first phase. Those candidates who are not allowed to participate in the interview process after reducing the cutoff, they are allowed those candidates. They have allowed those candidates to participate in the second phase examination. That is illegal because we are waitlisted. We are waiting there. They, after publication of waitlist, they published a notification saying that they are not the suitable candidate. We are going to reduce the cutoff. They reduced the cutoff. Subsequently,
What is wrong? It is not. It cannot be done.
Like-
If they don't find a suitable candidate and they want to fill up
my
the.
cases, we are the suitable. We are the waitlisted.
So how do you know you are above those persons in merit?
The result is not published.
So how do you know? That's what we are saying.
That is also our prayer. Result should be published with marks. Until unless results published, we cannot ascertain.
No, why? What is the reason that you have a tangible apprehension that you are being wrongly excluded or somebody is being favored? What is the tangible?
Well, kindly see the documents. I annexed some documents to show our prima facie case.
Let us see.
Yes. Kindly see the advertisement first, 218.
Oh, that is immaterial. You participated with open eyes. Don't go to the advertisement.
Kindly come to page 237.
Yes.
First of all, kindly see 230 page 230.
ভুল আছে এসএসসি or included something. এখানে হলো recruitment বন্ধ করেছে. Essentially is wrong in that sense.
This is the earlier cutoff in respect of the written examination, 230 page. And the notification is at page 229. It was the general information for the candidate of Group D recruitment examination 2017-2018. Kindly see may I read the information?
Correction হয়ে গেছে. ছেলেটার নাম করতে পারেনি, আমি করতে হবে, অ্যাড করে দিতে হবে.
করে দেবো। ডিপ নিয়ে আমি করে দিয়ে তোমাকে তো কপি পেয়ে গেছো, শুধু এটা করছো।
Yes.
Then kindly come to page 320, 230. 230 is the old cutoff.
Yes, we have seen that. Just
And page 231, the revised reduced cutoff in respect of only one category, that is OBC A. The last column, 231.
correct. So what is wrong with
What-
that?
Then kindly come to page 237, 236,
OBC A.
OBC A. Just 40, it was 47, then it was reduced to
6.5.
46.5.
Yes. Then
236.
yes.
It was the interview call letter of Sujoy Chaudhuri. He is the OBC B category candidate. After reducing the cutoff, even he participated in the first phase. Again, they have given the chance to Sujoy Chaudhuri to participate in the selection process after reducing the cutoff. Although OBC B cutoff has not yet been reduced. Only OBC A cutoff reduced.
Where have you stated this in your way? Show this specific averment in
Yes,
the way.
yes.
And you have made him a party. Have you made him a party?
No.
Then how you can make these
We
averments?
don't know the address. We don't know details until unless the authority supplied.
You have said so in the way.
Kindly see the paragraphs.
Did you ask them to give the details?
No.
You have taken no steps. How we can look into this? You can say anything about anyone. That will not look into any other material.
Kindly see page 197. Page 197 onwards, the general we have stated regarding the general information for reducing the cutoff, and page 198, paragraph 14, Roman 14.
We cannot look into this. We cannot.
And also kindly come to page 230, 237.
Yes.
At the stage of second phase, they reduce the cutoff of interview. Is it permissible?
Why not, sir? If they are not getting sufficient number of
We are the
persons,
waitlisted candidate. After interview, they declared us
so
waitlisted.
every waitlisted has to be considered. Is
But
there
there is
any
a-
law that all waitlisted have
In
to be
the selection,
considered?
there is a provision
Unless
for
they
waitlisted.
come to your position in terms of marks,
They
how you
will-
will be considered?
Marks has not been declared.
So therefore, we are asking you again,
Yes.
if you want the benefit of your wait list, can you challenge the terms and conditions of
Well,
recruitment?
we are not seeking the benefit of waitlist.
No,
No,
you don't want.
no. But until if the marks is published in the recruitment process for maintaining the transparency, then kindly come to the page 238 once. The general category, your category merit result.
Yeah.
Kindly see
Page?
page 238,
Yes, we are at page 230.
page 240. Kindly see page 240 once. All the 6,000 candidates, you are candidate, only your general category candidate got chance in the your category list.
What are you trying to show? We don't know. We are not able to appreciate. What are you trying to show?
Page 240. This
Yes,
is
we
the
are
list
looking at it.
pertaining to general category candidate.
Yes,
They publish the result
yes.
in respect of general candidate. In the general category, those candidate who are separate group, separate category, if their marks is higher than the last last you were
See, on if and but you cannot get a relief. That is precisely what we are saying.
see the least ones without
We are
any
looking
result.
at it. We
Phase
don't know
two,
what you are trying to show.
all candidate you are category candidate in the general category.
so what is-
No one from other category got chance. Is it possible?
No, no.
In a
Just now
recruitment
we have
process.
seen they have reduced the cutoff for OBC.
No, kindly see the UR category list. All are UR.
Why not? UR must be, vacancy must be very high. This does not mean this is the only.
They have to publish the result once.
There is no presumption that this is the only.
They-
This is UR. There may be OBC.
Then without any disclosing the marks.
So therefore, you are only concerned with that they should publish the marks. There is nothing else. Now, under the rules, where does it say that marks have to be published? And on your apprehension in the mind, why a court should direct?
Kindly see the rules.
Unless you can show that the rule requires the marks to be published, or you can show a tangible apprehension that yes, they are not publishing marks for this extraneous consideration, why we should come into this?
Rules and in the rules and in the advertisement, it is mentioned that the marks obtained in.
So read.
Can you see the advertisements once to
Yes.
218? Annexed A.
Let us first see your prayer in the OA.
Yes. Kindly see.
Which page, please?
214,
204.
214.
Paragraph 8. In the advertisement, there is a provision for mention that there is no provision for negative marking. But when the question booklet was there, in the question booklet that is mentioned that for each question for negative answer.
And after writing the answer, you did not object, knowing that they will be deducting the marks. You waited till the result was out and then you said,
Then-
how you can do this?
Then
Wonderful.
within 2 months we
Yes,
have.
yes. We have understood. So you know that why there is marks, negative marks have been deducted from you. You want them to add it. Under which provision such a direction can be given by us in judicial review that you add the marks which you have deducted and you declare the result. That's your first prayer.
In the reply, they have stated that they published a online notification.
We are not we are asking you, this is the prayer now before us.
Yes.
Show us any judgment that this can be done in judicial review. We will say that you add the marks which you have deducted for a wrong answer and then publish his result. Why? Because there was no clause in the advertisement, but it was there in the answer book or question book. This is a,
Advertisement was clause there regarding negative marking. There is no provision for kindly see the advertisement.
so even if there was no provision in the advertisement,
Provision is there.
then you did not challenge.
No, what has happened in the advertisement mentioned? Kindly see the advertisements once, 218. May I read the advertisement?
Yes, read it.
Kindly see 219.
Yes.
Notes are there. There will be no negative marking for any wrong answer. West Bengal Group D Recruitment Board.
Now,
will
when
be-
we said this, you said no, there is a provision. So there was no provision for negative marks. That is what we are saying.
But in the question book.
But in the question book, they have said that there will be
Negative
negative
marking.
marks, but you did not challenge. You participated.
Admittedly, we did not challenge.
So therefore, that's an admitted fact. You cannot improve the fact. We appreciate that. So in this, keeping that fact in the background, in that context, how can you challenge? Can you challenge? And is this prayer is maintainable?
Prayer A?
Yes, please read it.
To give a direction upon the concerned respondent authority to consider the candidature of the applicants herein for recruitment of West Bengal Group D post 2017 by allotting marks which has already been curtailed from the
curtailed.
applicant on the ground.
How it can be given when you knew at the time of writing exam that this will happen? How it can be done? That's why we are asking you. How it cannot be done. If at all, immediately after coming out of the exam, you could have challenged it. The result has been declared 2 months after the exam. After the result is declared, you have challenged it. When you have filed the OA?
January 2019.
So much after declaration of result also. 4 months after declaration of result. If we remember correctly, in August, the result was declared.
Yes, 18th August.
Then such a person, he deserves, and such a relief can be granted to him. How many of you are there?
In the original application, we are 300, more than 300.
How it can be done, sir? Tell us the law. Please show us the law. How it can be done? Such a prayer, how it can be allowed?
Regarding the prayer number 2, prayer 2.
Yes.
To direct the concerned respondent to give appointment to the petitioner and after considering their marks in the written interview.
So therefore we said it is in 2 parts. At the very outset, we said it is in 2 parts.
Yes.
The other part is that now you are in a wait list.
Wait list.
So what is whether you are to be granted any benefit or not?
Until unless the marks of all candidates is published, how do I compare with the marks?
We will not direct for that at this belated
And
stage.
kindly the publication prayer 3, publication of the result marks of all candidates. Because our challenge is that you are category 6,000, you are category candidate accommodated. Is it possible?
6,000 you are category.
Probably.
What do you mean probably? You are the petitioner, you cannot say probably.
4,000 probably.
Where is that averment regarding your category?
Yes.
Only your category.
Yes, yes.
State is also a party.
Yes.
Must be. The recruitment, the wait list is still valid.
Yes. According to us, this is my instruction that 600 posts are lying vacant till date.
600 are lying vacant. Wait list is still
And what
valid.
has
Then
happened
why?
in item number 46 and 47 today's list, we challenge the original application after getting marks. 5 candidates challenge the recruitment process on the ground that selected candidates are marks are lesser than the petitioner.
How do they know when marks have not been published?
No. They got the marks on by way of RTI.
Why you did not go for RTI? Who stopped you?
After getting that is my challenge, because my lord, after getting the marks, if the candidate came to know that they are not appointed,
You are
but their
appearing in
marks
that
is higher
case.
than the
In
appointed
that case also you are appearing.
Yes. 46 and 47. He is also my
But in
friend
that
also.
case, my lord, I raise the issue of my lord, limitation as because in
Limitation.
2019, my lord, the results were published. According to them, my lord, in terms of that, my lord, the amendment means in the writ petition as well as in the original application. My lord, they approached the learned tribunal in 2025. So
They
after
approached the
6
tribunal in 25.
25. And my lord,
OA is of 2019.
not this one, my lord. The other matters, what my learned friend has said, my lord, this matter, my lord, it was served only on my lord Friday evening in the office of the my lord, the Staff Selection Commission. Now, my lord, although in the I said, he said he will rectify it. But Group D recruitment board is no more in existence. It has been replaced by Staff Selection Commission. So, my lord,
Which recruitment board is not in existence?
this Group D recruitment board,
Acha.
that is
They had issued the advertisement.
yes, my lord. Well, that is no more in existence, my lord. It has been, my lord. Now the Staff Selection Commission has come into existence in terms of the, my lord, one notification of the government. Now, my lord, these being the situation, my lord, we got it on Friday evening.
May I give the reply, my lord? Earlier it was.
Now, my lord, and that the other application, my lord, which my learned friend has said, my lord, I have raised the issue of limitation. My lord, that is there. And that is the reason, my lord, your lordship was fixed them at an adjourned date. He said, my lord, he will produce that, this most likely this way he will produce before your lordship. This was the reason it was adjourned.
That is the
And my lord,
connected
this
way.
one,
Item number 3 before your lordship today.
So,
We
my lord,
approached by filing the original application in 2019, that is pending before the by exchange of affidavit and the hearing board, it is pending. Now what has happened after getting the RTI information, some petitioner from item number 3 came to know that their marks is higher than the appointed candidate. Then how they have prepared the result, and on the basis of result they have
The same applicants who are
Yes,
there in
yes.
3.
2019 they have filed the original that is pending. That's why I filed the present writ petition seeking that the next date is September 2026 before the tribunal. We are all along fighting for the result, marks, and after getting the RTI, if the candidate came to know that their marks is higher than the appointed
When did
candidate,
you make your application under RTI?
yes,
When you made your application under RTI?
petition কি পরিতোষ ঘোষ
2024 or 2025,
Why? Why?
because we exchange after we file the
So
original
therefore you can do
application.
whatever you want whenever you want.
No, no, my
After 4 years, you will file an RTI and then approach the
No, but
court.
We approach
Wonderful.
we approach the original tribunal in the year 2019. And in the hearing board, the matter is pending for 2 years. In the meantime, the petitioner, some of the petitioner, two or
Then why did you file another OA? That we don't know. When your OA was already pending, why you have not incorporated this in the existing OA? Where is the occasion of filing a second OA? If something new comes, then you will file a third OA. Is that the way?
a new cause of action after getting the RTI.
It's a new cause of action. So that cause of action is extinguished.
In this no, no,
So
in,
2019 does not survive.
no, in the original,
What are you saying, sir?
in the
You can't
subsequent,
just make any submission.
no, in
You have
the,
to be legally sound in what you are saying. There is an existing OA, you are taking steps, something happens, you will file a new OA. Now, if you get something else, you will file a third OA.
present
To
original.
file 5 OAs.
May I give reply for? In the present original application, we challenge the appointment of those candidates, making them party. We made them party.
Why it could not be done in the earlier one? Why this multiplicity? Is it to be encouraged? Essentially, the cause of action is one and the same, arising out of an advertisement issued in 2017. And the result, there are many subsequent developments. So every subsequent development, you will file a fresh OA. And we'll have 5 OAs to just to consider one case of these same applicants. How it is justiciable? How the second OA is maintainable?
In the second way, only 5 petitioners there. Only 5 petitioners, not the 300 filed.
We don't know whether it is 5 or 300.
I have the copy.
Maybe. How does that justify filing of a second OA? Why a second OA should be filed and entertained by the same person for the same recruitment process? What is this? You'll do anything you want at any time. Tell us how that is maintainable. You are relying on that to tell us how it is maintainable. A second OA for the same recruitment process filed after how many years?
In the
6 years, my lord.
5 years after declaration of the result.
say first original application, we did not pray for any termination of the
So
appointment.
maybe tomorrow you will realize in the second way there is some prayer lacking. That's why we are saying then you will file a third way.
No, second way, my lord, after getting the RTI, immediately there.
No, what happens tomorrow if you realize that some prayer you could not make in the second way? You will file a third way. That's not the point. Don't explain the circumstance. Tell us whether it is permissible. We have understood that there are subsequent developments. Is it permissible for every subsequent development to file a fresh writ petition or OA? How it can be looked into in the subsequent way? Your only remedy was, you know very well, you are an applicant in a pending OA, some new information comes. All you are required to do is either to amend the prayer or file a supplementary. It's very simple. Every day you must be doing it. You will not file a fresh OA. So the subsequent ways, how it is maintainable. Now we are considering all together. You tell us. Because he is appearing for the respondent and he is raising an issue of maintainability.
Because well, in the subsequently, subsequent way, the prayer are completely different.
Therefore, we are saying maybe some new prayer will arise tomorrow. File a third way. We are not asking you to explain the circumstance. We are saying how it is permissible to multiply litigation like this. Show us any law.
Then kindly adjourn the matter for the day, my lord.
Yes, come tomorrow.
Yes.
Not today. This is not done. Candidates or litigants? The candidates in a recruitment process are there here only to litigate.
But into the subsequent original application, just I can answer that the SC candidate and OBC-B candidate filed the original 2 application, 5 and 3 or 2 and 3.
We have not understood, sorry.
The subsequent original application filed by the SC candidate, 5 SC candidates, not that all.
Their party's original application.
Original party,
Original
applicant party
applicant,
different.
they may be SC,
They
SC,
approach the tribunal with the
If
different.
earlier you can all combine and then subsequently, what is the reason for making a separate application?
Yeah,
The reason
the earlier original application for publication of result considering the candidature of the applicant.
300 must be including all category of people. 300 must be including all category of people.
Yes,
And
combined.
you are making an allegation against you are. We are trying to understand what kind of litigation you have come to the court with.
We made the allegation against the UR because my lord, UR.
There is no UR applicant.
Yes.
Then how you
Absolutely.
can make an allegation against the UR?
In the UR category list, there is no other category candidate.
There is an UR applicant joining you in an OA. Can you make an allegation against UR? Some of the applicants. Tell us. Don't explain the circumstance. We are on the law. What law permits different category of people to be joined and they are fighting amongst each other and they are all applicants? Is it permissible? Just by saying marks have not been published, marks have not been published. You cannot get an order.
And for non-publication of the marks, that has happened. In subsequent original application, you can
Raise the
see.
specific grievance that only UR has been called or excessive UR has been called and UR applicants are along with you in the. Can you do it?
Well, we can, because my lord, being a UR candidate, we have a right to get a chance or appointment in
Can't
the.
object on the number of UR if you are in the same category.
Well, I am not.
Clash of interest among the applicants themselves, which cannot be contemplated.
My challenge is that well, how it is possible
That all
that
you are
all
required-
UR category
If
got
you are
chance.
required, we are required.
Only UR category candidate are getting chance in the UR category list. That's my challenge.
Every candidate participates in a recruitment process. He emerges unsuccessful. He will say that everyone has been given an undue favor. Easiest thing to say. It's the easiest thing to say. But merely for such saying and assertion, should the court embark on an inquiry into the entire? Or ask them to produce this and that, every recruitment process, never recruitment process will take place. And for such candidate who with open eyes has participated in the recruitment process, reading the terms and conditions and making a prayer contrary directly and or diametrically opposite to the terms and conditions based on which he has appeared in the exam. How he can do it or she can do it.
The result is published, then the selection process. Because my lord, we get only 5 information. From 5 information, my lord,
Your prayer will
place
not
before it-
travel beyond the prayer at all. Not travel beyond the prayer. Come next Monday, examine it. How many matters?
But the
There's
2, 3, 4, I'm not
and
these type matters.
and 46 and 47.
46.
All come together.
Yes.
Please give a slip.
Yes.
The serial numbers.
Yes. लिखे तो चुप।
Examine it. You come with the examine it, then you come.
Oblige, my lord. Grateful.
46, 47.
You come with some judgments.
Yes.
We have observed so that you can come with the judgments if there are.
My lord, your lordship has said
They
my
have
lord,
not
whether
decided anything in us.
whether this waitlisted candidate still, my lord, is there or not. But there's a government circular which says, my lord, a panel is valid for a period of 1 year. I will also produce that judgment. My lord.
Saying it is still alive.
It cannot be, my lord.
And there is 600 posts lying vacant. Subsequently, there is no
Alright,
selection process.
My lord, Shankar Singh Das makes it as
And how it will be expired? Before expiry, we have filed they have contested the matter.
তুমি ঠিক করে নাও এসএসসি গুলো করে নাও আমার there is a mistake in the cost title itself. He has again incorporated group D recruitment board, but the same has been modified before the learned
Staff
tribunal.
selection board.
That
Liberty be given to me to amend the cost title.
In which case,
all three cases, my
Three
lord.
cases, only on 3 cases.
instead of group D recruitment board,
It will be staff selection commission,
Staff selection commission.
and they have served the staff selection commission.
now 5.
Lordship, in item number 5, I'm led by Mr. Trivedi. He is on his legs before court number 11. Grateful, Lordship.
Number 6.
Lordship, I think we're seeking a short passover in I am for the respondent CIL. The answering respondent. And the answering respondent in the CIL. School India Limited.
Subject to my lord kind permission.
আপনি কি শুরু করে বলবেন? আপনি কি বলবেন?
হ্যাঁ করবো মামলা।
বলবেন কি এখন?
Subject to my lord kind permission.
Your Lordship, then let
Repeatedly they are taking the time.
time চাইছেন short passover চাইছেন.
Tomorrow he will be here. He will be here tomorrow.
He will be there in some time, just
Tomorrow, not
My lord, may I submit to lordship? My lord, kindly hear me.
tomorrow. On the next day.
okay. Grateful.
This is a matter of 2020, my lord. Right now, my lord, he has only 2 years service dismissed. They are taking time repeatedly, my lord.
Seven.
I am for the respondent bank.
Yes.
Then, my lord, kindly, my lord, take the matter on 8th. Next day after tomorrow, because tomorrow, my lord, I have the matter, another court.
Well, Mr. Paulal
Ask someone to seek passover tomorrow. We'll adjourn.
I'm praying for a short passover. Item 7, Mr. Paulal Basu is leading me by
Not today. Call the next. Right. You are in which case? 6. 6.
I am 6.
As brave.
My lord,
Give next.
number 8.
This terminal.
Oh, তুই জিতেছিস তো 1 লাখ ভোট।
My lord, in this matter, my lord, I am appearing on behalf of the respondent writ petitioner. Well, I am suffering interim order, my lord, since long. And my lord, here, my lord, if your lordship already heard this matter, and my lord, your lordship has instructed them to, my lord, implement the, my lord, though verbally.
See, we were informed, we don't know. The advocate who represents the organization is unwell. Last week,
Mr. Shiv Shankar Banerjee is well, my lord, but junior may be, my lord. Mr. Shiv Shankar Banerjee is, my lord, leading this matter, my lord.
What's his name?
ফোন করেছিল দাদা ফোন করেছিল my lord.
We don't know.
No, Mr. Shiv Shankar Banerjee is appearing. I know him, my lord. And I have also,
He's the appellant.
yes,
One appears to be appellant. If you know him, please let him know.
Yes, yes, my lord. Hey,
This is the MMCC matters.
no, my lord. Here, my lord, the promotion, my lord, I have obtained my degree through my lord distance course, my lord.
It is not MMCC.
No, no, my lord. MMCC mostly have been implemented, my lord. Those who have your lordships passed the order, my lord. Before.
We appreciate the learned advocate.
Yes, yes, my lord.
Representing the organization.
My lord.
They have prevailed upon them.
My lord, my lord.
But now your side is.
Because of your lordship's intervention, my lord, it has, my lord. Otherwise, they, my lord, went up to Supreme Court and then review.
Now your side in many cases having a very strong view that no, we want interest.
My lord.
Unnecessary matters are pending only for interest.
My lord.
We don't know why, but they are entitled to judge.
My lord. My lord.
Number 9. Then
my lord, in earlier occasions, my lord, my appeal, memo of appeal, my lord, kindly come to page number 4, my lord. And on that officer, I am that I saw the stop. Now, my lord, my appeal page number, that is the last para, my lord, last one. That single bench in command that 74 being dated 35 that is annexed dated in page number 10 of the annex, sir, my lord. Now,
What are you reading, sir? What you are reading?
I am reading the memo of appeal in page number 4, the last paragraph number that is the 3, the last sentence. The annexer page number 10, which has not yet been decided by the honorable single bench. So I have had a copy of the order regarding the pension from the commander and the government of India. Or annex that be decided.
Yes.
my lord. The annexer team or of my writ petition, it is, my lord, the B- BRO number 488 of 1997 and online letter has been given that the pension is allowed. So I have filed this another separate cause of action apart from the High Court or even in the Supreme Court. This Honorable High Court, I filed the writ petition, did not touch my annexer regarding the actual cause of action happened in my writ petition. So that Honorable single bench already decided the order of Honorable Supreme Court. That order does not touch this my writ petition because I am not concealed any material facts from the Delhi High Court to Supreme Court. Only I am touching my pension, which has been eligible and sanctioned according to my law under Rule 19 of the resignations. My lord, can you read that law?
You cannot, that issue is decided. Your relief for pension was
Yes,
considered by Delhi High Court. It was rejected. Supreme Court also did not entertain your plea against the Delhi High Court. Therefore, the Honorable Single Judge has said now we cannot consider pension.
Delhi High
How
Court-
it can be considered? On any ground, it cannot be considered. You cannot come up with a new ground every time and say that consider the same claim.
No,
You cannot do that.
That is not the new ground. Delhi High Court, the pension has not even touched. Kindly come to this Delhi High Court judgment.
Yes,
my
we have just gone through it, sir.
lord.
We have just gone
Yes,
through it.
my lord.
Therefore, we are saying that was the substantial relief before the Delhi High Court. You wanted pension. They said under 17B, you have fall under 17B, you cannot be granted pension. That has affirmed up to the Supreme Court. Where is the question of re-examining? Cannot be re-examined. There is no scope. That's all.
But whenever I went to the Delhi High Court, I preferred the SLP against the order of the Delhi High Court. Now, Honorable Supreme Court did not touch regarding the pension, only the salary.
Yes, only for salary they allowed.
My pension.
Salary already it has been granted to you.
Yes, yes. But my question is, my pension has already been sanctioned.
That cannot be reopened now. There is no scope.
My lord, one thing, I am a force, my lord.
There are
I
two
will
things,
do
not
my-
one thing, there are two things. One thing is that it cannot be reopened now. The second thing is you have filed the intra-court appeal after 851 days.
My lord, one thing, this is
The single judge dismissed the order when
my lord,
it was
the
dismissed.
code, my lord, the code is
What is the
such
date?
powers, my lord.
Writ court's order, what is the date? What is the writ court's order? Date of the writ court's order.
The annex or not, my lord?
Hmm?
Annexed or not in this appeal?
12 July 2022. We have got it. And appeal was filed when? 24. Where is the condonation?
I am coming to that. I have got it.
Where is the condonation application is?
My lord, 8
Can number?
and number 1. That is my
There
lord.
are two can applications.
2 can application.
And two.
That
No,
were most probably.
what is can one? Can one is not the condonation application. What is can one filed for?
57 days, my lord. This is
Interim order
can
is for interim. Can two is your condonation application, not one.
my lord, but here is the written the clerk.
There is
Clerk and law clerk is there.
anyway. So can two is your condonation application. That hardly matters. So
Very condone, my lord. This is a post, my lord, very poor. During after the retirement and resignation, thereafter joining the service, thereafter resignation, my lord, the family was ruined because due to the family's cancer, my lord, wife has been dead, so that he could not stable at all.
see
So he lost
the period
my lord.
the period of delay itself is not to be considered. The period is to be considered with coupled with the fact whether there is a sufficient cause for the delay. There is nothing in your application. There is nothing. In the condonation, there is nothing. In the main matter, there is nothing. Issue already decided. Single judge says we cannot look into. Very unfortunate. That's all.
My lord, issue has
You
not
come.
yet been decided by the
Heard the
second bench,
learned.
my lord.
Pending application.
Number 11, your lordship, in this matter, Mr. Gautam De appearing behalf of the appellant, your lordship. Due to unforeseeable circumstances, he is left the court today, your lordship. Praying for 1 week, not only 1 week adjournment, your lordship.
About the respondent.
Item number 12,
You know,
Insurance.
No, this is not. This is West Bengal Power Development Corporation.
Yes.
I am not insured, Lordship.
The point of law which you got here. My lord,
Can we just go through the order once?
yes, my lord, this is general.
Lordship, there is a delay. I am not standing now.
Point of law, it's
How many days?
72 or something like that. I am not standing now.
72 days.
There is a, you have filed an application.
Yes, yes. Section 5 is there.
Section 5 has been filed, 72 days delay.
Can number?
Can number 2. Can 2, my lord, is my application. Should I place the order or your lordship will go through your lordship?
The petitioner belongs to two categories. One is the OBCA, he had the certificate, as well as he had the exempted category certificate as a land loser. My lord, at the time of filing, my lord, if your lordship comes to the or judgment in your lord.
Concept of land user in
Yes, my lord.
There is an act. There
Yes.
is an act of 1999 which has been promulgated by the state of West Bengal, where it is not for any power generation unit, just like before your lordship. It is for the entire state, whether it is for corporation, whether for council, whether for any uh, municipality, wherever there is any uprooted employees are there, the families are there. One of the
For erecting any infrastructure of the corporation.
yes, one of the land has been taken, so they has been uprooted from the land. One of the family members
So under exempted category, they become entitled to consideration for appointment.
for enlisting their name with the card with the Benting Street, that an employment exchange is there.
That we have noticed. For what purpose?
For they will then when we will apply when we will publish an employment notification, we are required to apply to them that I have given this thing, these are my requirement. So EC category as this, exempted category as this, you
So
forward the number.
what is the percentage of exempted category permissible in a recruitment process?
117, my lord. Kindly come to page 117. There is a
That
notification 22nd November 2018. My lord, this is the sponsoring
What is the
candidates.
percentage? It must be limited to some 5-10%, something
Yes,
like
ma'am.
that.
It's given, man.
So this is horizontal.
No, sir.
Exempted
come to-
category is horizontal.
Is horizontal.
Exempted category is horizon.
Horizontal, but my loan offense client never.
No, just give us
Yes,
the
yes, horizontal.
percentage first.
Yes,
Let us know the facts. We'll hear you, sir. Don't be impatient. I'm not aware of the scheme, therefore we are asking.
My lord, kindly come to page number 46. This is the advertisement. And in the advertisement, my lord,
Sir, what
kindly
is the
come to
scheme?
page 40.
What is the scheme? How much, what is the percentage of vacancies earmarked for exempted category?
For this particular examination,
No, it cannot be for an examination. When there is an act, it must be specifying.
that act I have not brought today. Lordship, if your lordship wants, I will bring it tomorrow.
At least for myself, I'm not aware. I would like to see it once
I understand.
before we proceed.
Should I get it on the next day? My lord?
Tomorrow?
Tomorrow I have got some difficulty.
Any-
Day after,
The-
day after lordship, I don't know.
Yes. Part of the scheme apart from the act, just so that we know what it is.
Yes, yes. Act is there. I will government gazette notification. I will take
Wednesday. Wednesday.
Wednesday. हाँ, 2026 SCC online SC 22.
ঠিক আছে।
Deep level.
Item number 13.
For the respondent.
My lord, Mr. Shami Mulbari appear for the appellant. He's engaged in courtroom number 11.
I am appearing on behalf of the Life Insurance Corporation of India, appellant, my lord.
I'm appealing for the respondent number 3, Oriental Insurance.
My lord, as per your lordship, in earlier occasion, your lordship directly to file a report, my lord. My
The
lord,
admitted dues have been paid,
yes, yes.
paid to you. No.
I am for the respondent to already paid.
Ah.
Already paid the bereaved mother was.
If anything remains,
My lord, only
Group insurance.
group insurance from you.
Lordship, this group insurance which was given by the Oriental Insurance, first of all,
what is the disposal? So, only that only.
we have no liability to pay because first of all, we're not a party to the original.
The employees insured under a group insurance scheme by the employer, and that insurance scheme is by you.
But they had defaulted in applying for the claim.
So the employer has defaulted.
Lordship, and that because of that it was repudiated.
Repudiated.
And we were not even made a party to the original writ petition.
But appellate.
So then how that issue can be considered here? If there is a repudiation, it has to be challenged.
If the last occasion, lordship the leave granted the supplementary affidavit, then made party Oriental.
No, but then on what ground, how it can be considered, that we are asking.
Life insurance, lordship the report the life insurance in the supplementary affidavit, they are the NBS of 10 lakhs 21,800 and the group insurance of accident claim is the 50,000 lordship.
My lord, last occasion, my lord, if your lordship kindly trouble to turn your lordship order, that is the 9th February 2026. Only the adjudication portion is the interest, my lord. First paragraph, my lord. We have challenged the interest before the Honorable Division Bench firstly, and Honorable Division Bench has been pleased to stay the interest portion, my lord.
This has been served on you.
Yes, yes, I have already served. And if your lordship kindly trouble to turn the order number, order dated 27 March 2025, your lordship has been found from the order of the division bench. If your lordship kindly trouble to turn 27th March 2025 order, page 3, my lord.
Page?
Page, internal page 3, order dated 27 March 2025. March.
Oh, yes.
My lord, got it? Okay. Well, page, internal page 3, my lord.
My lord, the state injunction, stay order has been time frame extended, my lord.
Now it has been paid to all three.
Yes. Even in the read petition, there is no prayer for interest.
Huh?
In the read petition, there is no prayer for interest, my lord. And civil dispute, they are not suppressed the material fact before the honorable
Yes,
court.
there was a suit pending. You were
That's the
party to the
injunction.
and in the suit there was an injunction. That injunction was vacated in September or October 24th.
Yes, thereafter, after injunction, they have filed a read petition.
So after vacation of the injunction, when did you make the payment?
After vacating of injunction, they have filed the read petition before this honorable court. Therefore,
No,
we cannot-
once the injunction was vacated, did you make the payment?
After the injunction, they have filed a read petition before this honorable court.
After
5th August 2024, my lord, kindly see 5th August 2024, injunction has been vacated, my lord. Thereafter, kindly see your lordship in my stay application. They have filed the read petition, my lord.
Why we are
Ahead of the filing of the read petition, my lord.
why
Kindly-
we are asking you that after the injunction was vacated, what prevented you from giving the dues?
Thereafter, they have filed a read petition against the LICI.
You were party to the suit.
You have party to the civil suit. Thereafter, they have filed a read
You
petition.
were party to the suit.
Yes, I am the party of the suit.
So you knew that the suit vacation, the interim order has been vacated.
Interim of the vacated on the 5th August 2024.
So therefore, when you were party and you knew that the interim order has been vacated, why you did not make the payment?
They have not. They did not disclose the. They have not, after the vacating of the injunction order. They have immediately they have to read petition. They have filed read petition. Filed.
In August, when the interim order was vacated by an order passed in the suit to which you were a party, then what prevented you from paying the admissible dues to them in August? That we are asking. Why they had to come to the court again?
My lord, they have come to the court against between the party. They have filed the read petition against the LIC and not implement the party as a mother-in-law.
Forget about mother-in-law. When the interim order was vacated, what prevented you from making the payment?
My lord,
In August 24th.
After 1 month, they have filed a read petition, my lord. Within 1 month.
So there was a stay that don't pay the dues.
Within 1 month, they filed a read petition, my lord.
What prevented you? We are asking you for the 5th or 6th time. What prevented you from making the payment when the interim order was vacated in August? Who stopped you from taking the payment? Why you did not
My
pay?
instruction, that time we were in process, my lord. And after immediately completion of the vacating the
How much time it took you to process the dues from August 24? When you made the payment?
Thereafter, they immediately filed a read petition, my lord.
How many times you will say that? Perhaps 8 times you have already said it. You can keep saying the same thing.
Yes, my lord.
You try to dodge the court's query, that will not help you.
Yes,
Ultimately, you will have to give a reply.
Yes.
Whether you give it after 10 questions or you give it after the first question.
I have
That
instructed.
is not going to help you
Yes. I have
by
instructed-
dodging the court's query. Yes.
I have instructed that time there is a process for disbursing the.
How long? Therefore, we are asking you.
But that I don't know. That is the.
You don't know.
Take instruction.
What is your stand? When did you make the payment?
I have to take instruction in.
When did you make the payment? You have given a detail. When have you
I
made?
have already made payment.
When? When? How many times we'll ask you? Every question we have to ask you 5 times before you respond.
My lord, date of payment is in the seat. My kindly see the report of the last column, my lord. Nature
Yeah.
of payment, amount of payment, and date of payment, my lord.
Huh?
Last column. No.
All payments made after 1 year at least. Why? Why?
The amount received the 8th May of 2025.
They are, but that time because matter was pending before the court.
8th May 2025.
No, gratuity was paid in April 24. So all payments, why you have taken so much time, that we are asking.
Yeah.
And for this period, why she should not be compensated? From August 2024, when the interim order was vacated, till payment of the dues, why she should be deprived of any interest?
There's a pending before the honorable court petition. Thereafter, we have preferred an appeal, and that's why there is a litigation between the parties, my lord.
Admitted dues, you preferred an appeal. Therefore, we asked you to come after making the payment.
Only interest portion, the stay of honorable division has
Only interest is in dispute. Her entitlement under these heads is not in dispute.
Yes.
There was nothing coming in the way of payment after August 24. Then why you did not pay? The amount is admitted. There was no order after August 24. Then why you did not pay till April 25 or January 26 or February 26? We don't know. Is there anything on record to show why it took so long?
No, I have to take instruction.
What instruction? What instruction you will take? That is the only issue. You have challenged it on the interest aspect only.
Look, they have filed. I appreciate one thing. They have filed the writ petition November 20. November 2023. Say 22nd November 2020, they have filed a writ petition, and thereafter, and after 5th August 2024, there is therefore pending before the honorable court. The matter is pending before the honorable court, and honorable court was pleased to heard the matter. Therefore, we cannot able to pay. During the time the honorable court.
So because that it was pending, you did not pay.
Honorable court on that time, honorable court.
That's what we are saying. Because the writ petition was pending, you did not pay. And because the LPA was pending, you did not pay. And when we said pay the admissible dues, then only you pay. Is this expected from any employer? That a due which is admissible, and when there is no order preventing you from making the payment, at least from August 24, are you supposed to withhold any payments? Can it in any way be justified? ABC. And her husband has passed away while in service.
No, my lord, in page number 3, honorable court has been. My lord, can you one respectful submission before this, my lord? My lord. Page number 3, my lord, in order dated 27th March 2025, the Honorable Division Bench has directed to LIC on, however, the appellant in the third paragraph, my lord, the appellant is directed to comply with the direction towards the disbursement of 1/3 amount of the terminal benefit each in favor of the respondent. 1 and 2 herein positively 9th April, my lord. On that date, my lord, Honorable Division has been pleased to pass an order of 27th March 2025, my lord.
What was the prayer in the writ petition?
They have filed the writ petition, my lord.
What were the prayers? We have said so many times, everybody in the court must be knowing that they have filed a writ. What is the prayer in the writ petition? Same thing you repeatedly keep saying. Same thing. They have filed a writ petition. They have filed a writ petition. What is the prayer in the writ petition?
Legitimate claim, you responded to fourth thing, grant you all
Where is the
legitimate,
prayer?
all legitimate claim.
Where is the prayer in the writ petition? Which page?
Page 23.
Page?
23. May I permit to read, my?
And regarding compassionate appointment, what is your stand?
It should happen, they have not filed.
Now that was not pressed. Wait. No.
Now everybody has got all three.
With regard to the first aspect, all three is 1/3, and the third one, the rest 1/3, we have received from this court itself.
So the son is also before us now.
Son is also before us.
You are representing.
I'm
All
repre-
three you are representing.
I'm representing the wife and the son. She represents the mother-in-law.
Why didn't you pay after the injunction was vacated?
That time the sufficient
Nothing, no one was stopping.
pending matter before
Your
the
Lordship,
honorable
may I say why? I'm in panel lawyer with LIC as well. Usually they get scared whenever there is an case going on, and they are so scared.
If they lack in courage, who is suffering?
Actually, and that's the reason that they don't pay.
It's not being scared. It is lacking in courage for doing something which they are supposed to do. Why should they not do it?
Lordship.
Why do you need a court's order for these things?
In fact, Your Lordship, in one of the matters in the writ petition,
Unfortunate circumstance of an employee dying in harness. All right, they were quarreling amongst themselves. But once the interim order was vacated, the wife must have been made a nominee. In the
Wife
records.
is the only nominee, in fact.
You were required to pay to her without getting into that.
suit is pending. Well,
So the court's order means nothing. Whether injunction is vacated or not, you will not
injunction is
pay.
vacated and there after the matter has been pending before the honorable court for adjudication, my lord.
That's why we are saying that mere pendency, how it prevents you?
As per my instruction,
How it prevents you from paying?
only the matter has been pending before the honorable court.
And after the single judge order, how much time you have taken?
Within time, we filed for an appeal.
Why? That's what we asked you on the very first day. Why? An amount which is admissible, that also you did not pay. Forget about interest part. So you are too scared to do anything and they should keep suffering. On the plea of saying that we are scared, you will not discharge your obligation and duties and they should keep suffering. How it can be done? Therefore, we took a firm stand that on that day, why you are not paid the admissible leaves? And now you come out with it. You have paid everything. We'll see. So there are two relevant dates. One is 5th August, 24, and the other is passing of the order by the single judge.
Single judges.
After both the dates, you have taken your own sweet time to make the payment. There's nothing to justify why you have not paid her. Forget about paying to all three. That direction the court has issued to pay all three separately, that's a different thing. But otherwise, in terms of the rules, whatever you are required to do,
The interest portion before the appeal court, my lord.
you think we don't know?
And the interest, we have challenged the interest portion.
So you think we don't know? We are asking you why you did not make the payment of admissible amount. We have challenged the interest amount. Wonderful. You have no answer for any query. Yes.
Lordship has found there are two aspects which is left at this present juncture. Initially, there were three parts. One with regard to the terminal benefits, which has already been paid to the 1/3 to each of them.
Terminal retirement all paid.
That has been paid. Second, what is left over is the interest, and third is what is left over with the Oriental, which is 50 lakhs, which is due and payable. These are the two aspects which is left at this present moment. Now, if we hit on the first aspect with the interest, therefore, Lordship has found there is an order to that effect. Even before the trial bench also, that the person concerned was ablaised while on duty. His terminal dues have been kept pending for so many years, and not only
he was
ablaised while on duty. Yes.
How?
Fire with
in the office.
No, in the office or in the office.
No, when you are saying on duty,
on duty.
What is that?
Duty.
How? Where have you said? Where is this?
Yes, electrocution. There was short circuit, but he was on duty at that material point of time.
Where is the specific pleading regarding his death?
Writ petition is there? Yes.
Till now you were unarmed.
was just taking help from her with regard to the document. Kindly give me a. In fact, I was just stuck up with the next two. Yes. এটা কোথায়? Death certificate.
Page 4, এই যে page 4 of the repetition.
হুম।
Internal এই যে এতে দেখো stay application 19
না আমি এডিটটাই
page 4 এই paragraph 4 page 4.
Para 4. Now, Lordship will find from death certificate, cause of death, that's hello.
Yes.
Now, Lordship will find the same from page 3, paragraph 4
Of the writ petition.
the writ petition.
Where do we find it? In which
Page 3
of?
The application page 19, my lord.
You know, they have
Page 19.
annexed the same. So the
Page
page
19.
Oh, 3 টা দেখছেন Josh.
19.
19 of the stay in writ it's 3. Postmortem report.
No, you have not said that he died while in duty. That's not your case. He has suffered our electrocution. But
Electrocution.
Where he has suffered it, you have not said. How you said that he died in the duty, while on duty? Dying while on duty and dying while in a harness are two different things. He did not die while on duty.
The postmortem report is annexed at page 29. Page 29 will reveal the report itself.
Yes, he died because of electrocution.
Now, be that as I'm not on pressing that hard, since now after all he has died on that particular day while he is in service, and subsequent thereto is terminal, all benefits were kept on hold. That is the reason why Shoma, the wife, she was the nominee, and she came forward for claiming for the retired dues.
And what was the suit filed for? By whom?
Suit was filed by them. Lordship will find it was when the interim order.
By the mother-in-law.
Mother-in-law. When it was initially filed, we are not even served. Lordship will find from the order itself. But after we have been served, it has been stated, if your Lordship kindly be with the order itself, wherein it has been stated with regard to C scheduled property. Now, C scheduled property indicates the terminal benefits of the deceased. Now, Lordship will find one thing.
Terminal benefits cannot be bequeathed. Terminal benefits have to be disbursed as per the service rules.
Yes. Yes.
No question of bequeathing the Terminal
Now,
benefit.
even that is also given a go by. What Lordship is on with the service rules, and even that is also being given a go by as well.
Therefore, we asked him that
Yes.
what came in the way. There was an injunction till August 5th, August 24. After that, there was nothing.
Nothing
coming in the way of payment. He says that writ petition was filed. So what? Whatever is your due liability, you should discharge it. Why should you keep it sitting with folded hands, knowing that they are suffering the loss of this person in harness? This is not expected from any employer, much less LIC. You are ensuring everybody's problems, and your own employees you are treating like this. Regarding the, and where is the repudiation of the claim? Repudiation, where is
repudiation
that?
of the claim.
Your Lordship, we were not directed to file any affidavit. If you are directed, we'll file the affidavit.
So how we have this fact on record that it was repudiated? When it was repudiated?
They asked for the same from them.
I know the Lordship, the cause for repudiation was that the employer LIC had defaulted in claiming.
We are not on that. When it was repudiated?
কবে রেপুডিয়েশনটা করে হয়েছে এখানে রেপুডিয়েশন রেপুডিয়েশন না দিয়েছে রেপুডিয়েশন দেখছি রেপুডিয়েশন আছে
Supplementary affidavit.
Lordship will find the same. It's to repudiate it on 8th of May 2025. 8th of May, they have stated yes. This is the ওরা supplementary থেকে claim is being repudiated. তারিখটা কত তারিখটা এটা তারিখটা no এটা হয় no it should be it is 29th of April 2025 intimated by the LIC on the subsequent
29th of February
29th of April 2025 yes. And intimated by the LIC on 8th of May.
There is a repudiation order sent to you.
This was not sent to me. It was initially, it was only placed before the erstwhile division bench.
You said intimated on
Intimated to it was not to send to me. It was in fact sent to them.
But it was
and handed over to us
on 8/5 itself.
On 8 subsequent day when the court was taking up the matter, it was handed over.
What is the date?
Date is 8th of May, Lordship.
Which page from where?
Lordship will find the page 7 of the supplementary. Yes, Lordship, the supplementary used by Rashmi Dasgupta. এইটা হবে এইটা হবে রেশমি দাসগুপ্তা এটা affirmed on affirmed on 23rd of May 2025.
Which paragraph?
Lordship will find from the page itself and the paragraph is, yes, paragraph is P on page 2. coupled with the annexure.
No, we asked you, where is the repudiation
Yes,
order?
Lordship will find here, page 6. Page 6. বীজ হবে এসেনশিয়াল পলিসিটা কে করেছে ওটা কত কত 5 and if Lordship kindly Lordship is on to the page.
No, there is no default in premium.
There is, Your Lordship. As per the
From page 6, it doesn't appear.
Lordship, as per the MOU between LIC and Oriental, every claim has to be made within 12 months of the event. They have made the claim after 19 months.
You said that there is a default in premium. There is no default in premium.
It's a default in premium. Default in claim, I said, Your Lordship. Oh, I'm so sorry, Your Lordship.
There is no default, there is a delay. And who is supposed to present this claim? The employer or the? Why did you delay for this? Why did you delay in this? This has been served on you, supplementary affidavit.
This is their supplementary.
No.
My supplementary.
This is their supplementary.
So what do you have to say about this? Page 6.
Sometimes funds are being put on hold. Sometimes the policy is being placed after a later date.
We have replied that mail, page 7, my lord. You have my reply mail.
Page 7.
Page 7.
No. The one thing which I like to indicate, Lordship will find. পলিসি হয়ে গেছে তো দুই 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 তখন অ্যাক্টিভ হয়ে গেছে ওইটাই তো বলছি ওইটাই বলছি দেখছি বলছি Lordship will find this stood answered as per the claim subsequent. Page 9 will reveal what they have answered. The only reason is that they have submitted late. And for a kind perusal, if you Lordship kindly to page 11 for once.
You have read all the documents.
This is thing.
You have just read all the documents. The policy, it was their obligation to submit the claim form along with all documents.
And in fact, it is
within
being
12
stated-
months, and if submitted within 12 months, then the obligation would shift to them to process it within 30 days. They have not done anything.
No, no, because the claim intimations will be sent by the representative of the LIC to the insurer.
So you are saying what we just said, but in other words.
That's it. Therefore,
Yes,
this is the situation.
total inaction on your part. They are highly unexpected from such an employee. Because of you, their policy has also lapsed. So, and you admit to it. It's not disputed. You say just because we have delayed, why you are not paying? Just look at your correspondence. Come to page 7. Now the claim is being repudiated by your office on the mere reason of delayed intimation, which is not justified at all. Please review how they can review.
This is my reply, my lord. Page 7 is my reply.
Correct. Yes. That we have understood, sir. That's why we are saying it is admitted by you that you have delayed.
So now the claim is being reported by your office on the mere reason of delay.
Of delayed. Mere delay. So delay means nothing to you. And if someone makes a claim delayed for your under your policy, then you will repudiate it. You are in the same business. You know the sanctity of the terms and conditions. Still you are doing it. And in the group insurance policy, who was the insured? Who was the nominee?
Shoma.
I have to take instruction.
Must be the wife.
হ্যাঁ সোমা তোর ইয়েটাতেই আছে সেটা তুই দিয়েছিস কোর্টে ওই এটা ছিল না তোর একটা কি ওই আগে একটা কি আছে ওখানে আরে ওর একটা ইয়ে দিয়েছিল আরেকটা সাপ্লিমেন্টারি দিয়েছিল ট্রায়াল বেঞ্চ
And what is the sum assured?
50
lakhs. 50 lakhs.
না ওটা না ওর একটা ইয়ে আছে ওটাতে হ্যাঁ হ্যাঁ এটাই বলছি
Did you take any legal steps against them? Did you? Nothing.
Liberty may be granted, but
What should be done? She cannot be deprived because of you.
Let them pay off and then thereafter they fight amongst themselves. This is the only remedy.
There is
Will
no,
give me liberty, I will take against legal action against the Oriental Insurance Company in accordance.
that you will do against them. What about her? That you will
My
do
lord,
against.
main writ petition. mm, uh, Main writ petition, the issue of the has not come, my lord. The issue of the uh, personal accident death claim, my lord.
Read the prayer, read the prayer. Read the prayer. We have just gone through the prayer. All legitimate dues, all legitimate terminal dues and all due retiral dues, both things. You expect this woman to articulate every due that is that she is entitled to upon the sudden demise of her husband. Until till she does that, you will not pay. Is that your
No.
stand?
Well, they have not filed any affidavit on the affidavit in opposition or every reply in regard to the supplementary affidavit, Oriental Insurance Company.
Huh? Which supplementary affidavit?
This one, Rashmi Dasgupta, which repudiates the claim.
Oh. What reply is to be filed? This is not disputed. Who is disputing this? What have you said in the?
Well, kindly see my here, my.
Yes.
Full affidavit has to
Yes, you have only asked them to be made a party. Now they are parties.
They implement as a party, but they have not filed any reply, my lord, in connection with my application, my lord. Kindly consider, my lord.
They don't want to file, then they will not file. How are you aggrieved if they are not filing?
We wanted to file, but we were directed not to because as of now, adjudication was not on that point. But given that, your lordship, we have admitted that fault is on their part.
There is no scope for giving the dues after 12 months.
As per the rule, I don't think there is scope. Your lordship, if I may, let them pay the amount and then they can fight a legal battle with Oriental. And we will see on that. But here, lordship, apart from this, another point is that we were not a party to the original reputation. Here we have been made a party, a new point have been added. But if your lordship,
It is not a new question. See, the prayer is all the dues. All the dues would include group insurance.
lordship, but here, because of their fault, they hold the liability to pay.
Well, it is not our fault, my lord.
No, but they are saying they asked you to review your stand. So what comes in the way of reviewing your stand? That we are trying to understand. After all, she has to get the payment, whether you make it or he makes it. We are just trying to understand what comes in the way of your making the payment. Is there a total bar that after 12 months it cannot be paid?
I don't know purely, your lordship, but I'll take instruction on that and if your lordship directs on to that. But honestly speaking, lordship, I wish that the money should be paid to the.
No, everybody will, because that is, even they cannot say, nobody can dispute her claim.
Whether we pay or they pay, regardless.
And whether she can be denied this amount because of some delay or any lapse by another person. When her husband has paid the premium, there is no.
He cannot make any claim. Only they can only claim.
They can make.
I have no right to claim. That is the specific statement.
So we said at
Just
the very
lordship
outset.
I have come before your lordship with a clean hand because I have submitted all documents which are entitled to the petitioner. Therefore, and that
No, since all the dues have been paid, we'll give you one opportunity. Now at least she has got a substantial amount. We'll give you one opportunity. You take whatever stand you want to take. Then we'll pass the order.
Lordship, in that, will let me take the instruction from them.
Yes.
I can personally ask them to review if it is possible, and we'll file an affidavit for that.
But this is also not a part of the,
Please work on it, see how the red court can direct.
if there is a delay.
Some precedent.
I found. Let me also get ready with the armory.
Therefore, please.
Today I was a bit late with my armory.
Wait for your lordships.
to maintain.
Give us. Yes. We are looking at something which we have received from you.
Declare.
Yes.
My learned friend is here, Lordship. Item number 28, subject to.
Yes.
Yes.
Your side is here.
I have
Yes.
got the respondent.
What do you want?
Subject to Lordship kind approval after 15th June, any date subject to Lordship kind approval.
You are the appellant.
I am the appellant, Lordship. My learned friend is also here.
The learned
Any date subject.
appellant.
লিখে দাও। নির্বাচন নামটা।
Item number 31.
Reading the operative portion of the judge. In view of our above consideration and since the present case does not involve imposition of a penalty pursuant to a proceeding under the conduct regulations, we are of the view that the observation of the Honorable Single Judge regarding the provisions contained in the service regulation for sustaining the penal conditions in the order dated 8/7/14 were uncalled for and unwarranted. In fact, since the petitioner gave up his contest to the allegations, including the report of the subdivisional officer dated 17/12/13/2003 regarding the caste certificate based on which he sought employment being false illegal, the proceeding was not required to be conducted. Therefore, the disciplinary authority entertained the petitioner's request to resume duties based on the subsequent caste certificate dated 25/6/11, but subject to certain terms and conditions which were duly accepted by the petitioner. The non-challenge to the order of the appellate authority is also a similar lapse on the part of the writ petitioner. Therefore, there was no scope for the petitioner to challenge the consequences of the disciplinary authority's order dated 8/7/14. In view of our above consideration, we find that the writ petition was fit to be dismissed. The order of the learned single judge to this extent does not require any interference in the intra-court appeal. The appeal and petition are accordingly dismissed.
Item number 32.
Call the next.
Item number 15.
Next.
16.
Appearing on behalf of the appellate lordship.
This is the matter, Lordship, whereby the or impugn order dated 15 January.
There is an application under section 5.
Yes, Lordship, there is a delay of 116 days. Lordship, I have filed.
Yes, 116 days.
116 days, not kindly see the impugned order. There's nothing is there. After this order was passed.
So we'll go to the impugned order.
Not-
So we'll go
No,
to them.
That is not. Regarding delay, I am saying.
Yes.
But after considering everything, the money is ready, they are ready to pay. His Lordship directed that it will be paid by February. But thereafter, long thereafter, this has been done. Taking that, we are directed to sign certain documents or supply certain documents after all these. That's why I am not opposing. Otherwise, not died in harness in 2008. Immediately, application was made by December. That is not 2008 August, he died. December 2008, application was made. Repeated representation assured that it will be given compassionate appointment. Ultimately, responded in 2015. Thereafter, my lord, the approach court, they say that at the relevant time there was no scheme. Therefore, you are entitled to ex gratia. Ex gratia amount, my lord, the calculated documents are supplied. My lord, kindly read the order passed by this court. We are in now May 2026.
Lordship, bank was never accepted that they will get the benefit. It was stated in our report that if they found eligible, the ex gratia amount will be provided to him. Lordship, moreover, in the impugn order, there was a wrong observation by the honorable single judge that the amount has already been sanctioned and awaiting for disbursement. It was never submitted by the.
Let us see the order.
Lordship.
You want to file any opposition to the application?
But unnecessarily, your lordship kindly.
All right. No, we are asking you.
No. According to the he mentioned not in.
You file an opposition before the writ court.
Nothing.
Lordship, I did not file any opposition, but I have submitted a report in the form of affidavit whereby bank has intended to give ex gratia amount if the petition
Where is that affidavit?
eligible. Lordship, kindly come page Lordship 92 of my stay application, annexure A2, Lordship.
Did you ever apply? Did you ever apply for the ex gratia?
Yes, yes, we are entitled to. Lord.
Did you ever apply for the ex gratia?
Lord, yes.
When?
After this decision was court directed them to file fresh application, thereafter they considered and they have given Lord annexed this.
Did you ever apply for ex gratia?
Lord, initially we applied for compassionate appointment.
Did you ever apply for ex gratia?
Yes,
We
yes,
are only asking you this question.
Yes.
Where is that relevant averment that you applied for ex gratia?
That is Lord after this report.
Where is that averment? In which pleading you have said in the writ petition that you applied for ex gratia?
But that has been after that no direction was given. His lordship directed not kindly see the order.
We are asking you again.
Yes.
Have you ever applied for ex gratia?
Yes.
So show us the necessary averment.
Lord, your lordship kindly see that after hearing the party, I find that the matter can be more effectively adjudicated if the general manager is such and such is directed to inform the petitioner as to what documents which are still outstanding and or required to be filed by the petitioner. The communications have been made by 12 July 2024.
Her husband was working as?
Group D staff, Lordship.
You never made an application. There is nothing on record to show that you ever applied for ex.
Lordship, one more thing. Lordship,
Order, under court's order, it was submitted before.
Lordship,
We are not asking about the court's order. We are asking about you, whether you ever needed or you requested or applied for an ex gratia amount or not.
Lord, yes.
You are saying that repeatedly, but you are not able to show from anything. So unless your client has stated so, how you can tell us?
They say for the first time before.
Forget about, we are not listening to what they say. We are asking you. You were the writ petitioner.
Lord, your Lord,
Where is that necessary averment in the writ petition or any document to show that you ever applied for ex gratia?
Lord, kindly see the them writ petition. They have not annexed the writ petition.
You show us. We are giving you opportunity.
Annex the writ petition.
Yes, Lord, kindly see.
Yes. Which paragraph, which sentence you said that ex gratia was applied for and on which date?
Initially, we applied for application for a compassionate appointment.
That everyone knows. We are repeatedly asking you only one thing. When you applied for ex gratia?
Lord, your lordship kindly see in their application. This scheme.
Your admission is recorded in the impugned order that you never applied.
Lord, impugned order, it has been held that
your admission is recorded.
Lord, kindly appreciate. Lord, we applied for compassionate appointment.
Why you are saying that? That is known to all. We have said already. We are only asking you Why you did not apply for ex gratia? Why not?
Lord, at the relevant time,
And without applying, can it be given to you?
Lord, it has been Lord held by the court.
Show us from the scheme that without an application, it can be paid. Show us.
So kindly see the scheme.
Let us see, where is it?
Scheme is at page 104.
Yes, we have seen the scheme.
Yes. But your lordship kindly see that from the very beginning we are giving impression that we are entitled to compassionate account. That's why my lord application was made immediately.
So when was it finally rejected? When was it finally rejected? The claim for compassionate appointment was rejected or not rejected?
It was not just said.
So
that-
give us the date. When was it finally rejected?
But they have given a reply, your lordship kindly see.
Lordship, it's the year 2018, the date.
2018. After my lord
And
10 years, 18.
so it was rejected in 2018. Then what did you do?
But duty, it was thereafter, my lord, we approached this honorable court.
When?
But immediately thereafter, and earlier writ petition was.
When, sir? When? When?
Lordship, 2021, they have first approached the writ court.
And there is an order passed in that writ petition. Where is that order?
That order is not.
In court.
Yes, it is annexed to this.
Writ petition. Lordship, may I appraise your lordship?
Page 80.
Lordship, page 92.
92.
No, Lordship.
No.
My apology, Lordship.
Page 80, madam.
80, Lordship. 80, Lordship. Whereby
Lord,
bank.
then also, Lord, they, in spite of repeated direction, no affidavit was filed. And in the present writ petition also, no affidavit was filed.
On that writ petition, Lordship, bank was directed to pass a reason order in respect of the representation made by the petitioner.
For compassionate appointment.
Lordship.
So when the reason order was passed?
Reason order passed, Lordship. Third, Lordship. Reason order passed on 27th of July 2023, Lordship.
Where is that? Is it on record?
Lordship. Lordship, page 86. May I read, Lordship?
We are reading. Don't worry.
Lordship.
So after this 27/7/23, you never applied for expression.
27/7/2023.
You challenge this order in the next writ petition.
Yes, And Lord, when
So there is no occasion to make the application
Yes.
because you are pursuing your claim for compassionate appointment.
compassionate appointment, thereafter, my lord, when the court found, according to the scheme produced before this court, that you are not entitled to compassionate appointment, therefore you supply the documents so that they can consider.
So why don't you make your application?
Even after passing the order.
Even after the order was passed, you should have made an application allowing them to consider it.
Lord, they considered it.
Where is that consideration?
That consideration your lordship will get from the order impugned itself.
Again, we are saying, after the writ court passed the order, what prevented you from applying?
Lord, your lordship, during hearing for the first time, they disclosed the scheme. You had no scope.
But now you know the scheme, you have just placed the scheme. So we are asking you, what is preventing you from applying to expedite the issue?
Lord,
you apply it.
Lord, we didn't apply because of the court's direction that we are now, we agree to get the ex gratia, it has been recorded in the earlier order. That's why court directed us to furnish the documents. Accordingly, we furnished the document. They were satisfied.
No,
They said
Lordship.
that you have received all the documents. Now, kindly see the order.
Lordship, even after passing the order, we
No
made
document is considered by the single judge.
Lord,
At the stage of the single judge, there is no consideration for ex gratia.
kindly see this document.
We don't know from where you're reading these facts. We are not able to find these facts in the single judge order. The single judge says you are ready to receive and they should pay. There's nothing about application being made. Can it be done like this? You tell us. Under the scheme, they have been gracious enough to say that even though an application was required to be made within 6 months, even in 23, they are saying that we are still willing to consider. More than 15 years later, still you don't make an application. Why you are shy of making an application? What is your problem?
Lordship, may I pray one thing? Lordship, even during pendency of this appeal, we severally approached to the petitioner to submit application, but they vehemently
Why are you shy from submitting
they
an
will
application?
not submit anything. They said, I will not submit anything unless or until
You
I
want
got
to
the
submit or you don't want to submit? Take a stand.
Kindly see this order only. This is the order in the writ petition. Oh, order in the writ petition, but that's why
We are looking at which order?
No, not that order. It is earlier order by which we are directed to.
Forget about earlier order. That is the final order.
By the earlier order, all the documents are furnished.
We don't
In
know.
terms of the order.
You are required to make an application under the scheme. Making of an application is mandatory under the scheme. Unless the scheme is set aside, a direction cannot be passed to the contrary to the scheme.
But Lord, the scheme says that claim.
A scheme says application must be filed within 6 months of
Your
death.
Lordship, kindly see there was
Read
no-
4.1 of the scheme.
Kindly see the scheme.
See, the scheme is very clear.
Yes, Lord.
It says in 3B are the conditions
Lordship.
where we will give a compassionate appointment. If the person dies while on duty as a result of violence, if he dies before attaining the age of 30 years, within 5 years of his appointment, he has minor children, we will give him a compassionate. Otherwise, we will consider his claim for ex gratia. If he makes an application, if his income is below 60% of the last pay drawn. Now, without such consideration, can a court direct that you pay? You tell us, what is the law?
Lord, they have considered and submitted that he is entitled to pay. We have made ready. Lord, kindly see once the impugned order.
We have seen.
Lord, I am placing my 1 second.
We have seen.
Just see. This is the impugned order.
No point of time we
Wait, you sit down, please.
Lord, kindly. The impugned order, can you see? Lord?
How a council can give a concession contrary to the scheme and how the court can accept a concession contrary to the scheme. It's impossible, cannot be done.
Lord, kindly let me, Lord. Let me
Please
say
read.
this. Lord, your Lordship, I am placing from page 19. Compassionate appointment is not as well said, is not a matter of right, but has been carved out of the scope of regular employment to support the bereaved family from getting over the immediate financial crisis faced by such family due to loss of sole breadwinner. Compassionate appointment is provided as per the scheme, if any, prevalent in the employer's organization. In the instant case, though the petitioner had sought for compassionate appointment, but when it is found
that there is no relevant scheme under which compassionate appointment can be granted to the petitioner number one at the time of death of the employee. The petitioner are now agreeable to accept the ex gratia amount foregoing their claim for compassionate appointments. In the meantime, about 16 years have passed away, in which more than one round of litigation has taken place. Although the petitioner had claimed for compassionate appointment immediately after the death of the employee and is required to be given in a time-bound manner without inordinate delay, so that the whole purpose for granting of the same does not get frustrated, but has not been given even after 16 years. The respondent bank, assuming without admitting its stand to be correct prior to 2018, had never offered the ex gratia amount to the petitioner. The claim for compassionate appointment was also not expressly rejected. The respondent bank, being a nationalized bank, ought to have made the position clear at the earliest to the family members of the deceased employee so that they did not pursue their claim for compassionate appointment. Be that as it may, when the petitioners have now agreed to receive the ex gratia amount, the respondent bank is directed to pay the same as per the applicable scheme with interest at the rate of 6% per annum from the date immediately succeeding to the date of death of the employee concerned until the actual payment thereof. It is though submitted by the respondent bank that the ex gratia amount has been sanctioned and the bank is ready to pay the same, but no computation of the ex gratia amount has been either placed to the court or made known to the petitioner. But therefore, not during pendency.
So where is the fact regarding application? We missed it. Neither when we read we could find it, nor when you have read we can find it.
Here it has been.
You are reading it to show that you have made an application. Where is that application?
But application was not made.
So without an application, whether it can be considered under
That's why the court, in the court's order,
they are willing. They are saying they are willing.
We agreed to
You make the application. They will pay it.
We received the ex gratia. We received.
They are still willing, sir.
Not just not. We accepted. We are ready to pay. Take the ex gratia amount.
Yes.
Accordingly, Lord, the bank was.
There is no question of being willing to take. You have to apply and be found eligible. Then only.
It is too much technical.
You may say so.
Because Lord,
We have yet to see. We have yet to see a law. We have yet to see a law that ex gratia or compassionate can be granted contrary to the scheme. If you can show, then it will be a technical thing.
One aspect of the matter.
Yes.
In December 2012, we have applied. Lord, the bank for the first time responded in 2018 that you are.
See, the same thing you are repeating again and again.
Lord,
we are only on one issue. Without an application, can you claim a benefit for which an application is required?
Lord, in fact,
mandatory under the scheme.
Lord, in fact, Lord, in terms of direction, we furnish the document.
No. There is nothing on record. Your submission is not borne from the record, sir. Sorry.
Lord, it is on record.
You said that it is in the order. It is not there in the order also.
Lord, order itself. Lord,
final order.
Earlier order by which we are directed after our acceptance that we are able to take ex gratia. The court passed an order.
What?
Lord, this is the order. After hearing the parties, I find that the matter can be effectively adjudicated if the General Manager UCO Bank such and such is directed to inform the petitioner as to the documents which are still outstanding and or required to be filed by the petitioner. The communication shall be made by 12th July 2024. The petitioner shall submit documents sought for which are in the possession and custody by 24th July 2024. The respondent number 3, Chief Manager, UCO Bank, New Market Branch, will also meet the petitioner on a specific date. Thereafter, we
there is nothing regarding submission of.
Lord, submission of documents are submitted thereafter.
You are presuming. We will never presume. We will go by the order as it is. We will not presume that pursuant to that you had made the application. That we will not presume. You can presume.
But Lord, it is during pendency how application can be made. Ultimately,
therefore, at the outset, we asked you a simple question. Are you willing to make an application or you are not willing to make an application?
At this stage.
At which, when can you make it?
In fact, Lord, that has been.
So therefore, take a stand whether you will make an application or not. We will pass the order accordingly. Therefore, we are asking.
Lord, in fact, this is the position court also recognized that we have.
So you will not make it. We'll take it that you don't want to make an application. We'll record then. Please take a stand, sir. We are asking you to take a stand.
Lord, your lordship kindly consider the
We are asking you a
background of the case.
simple thing.
At this stage,
You have given the entire background. You need not labor anymore. You have given the entire background. You have taken us through the order.
if your lordship so direct, if leave us, grant us leave, then again we will file.
You file it within 4 weeks. They will decide in accordance with the scheme within 8 weeks thereafter.
Then everything is in your lordship.
Huh?
Your lordship is keeping pending matter.
No, no. Why pending?
Lord, otherwise they will not do. Last Lord.
All right, all right. After
followed, then there is a limitation of 6 seconds, but they have agreed to with very quick steps. Two plus 8 is 10 weeks, and after 11 weeks, give it.
My lord, I appear for the appellant. My lord, the impugned order, my lord, challenged hearing, my lord, has been complied. The appeal in a way has become infructuous, your lordship. My lord, my lord, they have also preferred a contempt in the
they have also preferred.
a contempt application, my lord. In the pendency of the contempt application, the order has been complied. Here is the order passed by the single bench, your lordship. And
This is the order passed in the contempt proceedings.
I am for the private respondent, lordship. I am for the private respondent. The order of the single judge has not been fully complied with. Lordship, kindly
So,
look at the.
so what can you say in the appeal? So what can you say in the appeal?
That they are now, they want.
This CPAN is this LP, this appeal arises out of 19409.
Yes, your lordship. The order which has been impugned herein. My lord, order is at page number 14 of my application, your lordship.
Those are the private respondents main.
19409. Where is that?
Lordship, page number 14 of my C application.
Lordship, it is my substantive right to assail the challenge the appeal, your lordship. The copy of the appeal has not been handed over to the respondent.
The learned advocate for the appellant
The appeal has been
Not
handed over
required,
to
sir.
the
If we direct, then she will serve, otherwise she will not serve. Call the next.
18.
Well, this is also my appeal. Well, this appeal is
Justice is
referred.
denied, the lordship. Sir, handing over any copy to the respondent. That has been-
What is the order under appeal?
Memo as well and this well, there is a delay also of 84 days. Well, in the memo, your lordship will find the order as well as in my.
Serve a copy, then we'll take it up.
Well, we have served.
Application.
Yes, yes. Well,
Is there someone appearing for the respondent?
respondent was here a while ago, maybe because.
Then we'll not take it up today. Call the next.
Lordship, in view of the resolution, I'm not pressing only one thing. May I indicate your lordship a contempt application?
Not today, madam. Tomorrow we'll take.
Lordship.
The appellant did. I am for the ECL authority, sir. The state is also a party.
State party, yes. State is a party.
Yes. And the order was passed, my lord, by the trial court, my lord, on the submission made by the state.
Not today. Let us see tomorrow.
But the ECL is the main authority.
Not today.
Not today.
We'll see tomorrow.
20. So I am for the writ petitioner respondent. Affidavit of service.
There are any other respondents?
Writ petitioner is the sole respondent.
So the parties are present.
Yes, both parties, my lord. The service, my lord. For your lordship of the bank, my lord, the landed single bench, my lord, set aside the order of the complaint authority, order of the appellate authority, as well as, my lord, reinstate the petition and allowing him 50% back wages. Challenging the same, my lord, the petitioner preferred this appeal, my lord. Appellate. The impugned order for your lordship, my lord. Page 125 of the stay application, it is also annexed with the, my lord, memo.
Yes.
Initially, 2011, that there's a defalcation of money, and the charge sheet issued. And subsequently, in 2020,
Have you complied with the order?
contempt pending, they are filing contempt after filing this appeal.
No, so subject to correction, after filing of the contempt application, the appeal has.
Khalid, look at the date, we are
Yes.
filing appeal within.
What difference does it make? Whether you file first or he filed first, what difference does it make? We asked you whether you have complied with the judge.
Till now, we are actually.
Why? You should have complied.
Because there is a specific judgment of Supreme Court. Reinstatement can be done by the court. Reinstatement done by the here, the reinstatement done by the court. The stage
So many judgments this is done. We have done it in many cases. We don't know which law you are referring to that a court cannot direct reinstatement.
in the disciplinary proceeding.
Show the judgment.
Paragraph 8, my lord.
Citation double.
2022 AIR SC 1551.
Yes. This is if there is a procedural violation. If there is a procedure, if there is a lack of compliance with natural justice, relying on Karunakar's judgment, this is very well known.
In this case, my lord, the Supreme Court says that the court cannot reinstate the employee, my lord, and here,
That is the way to read a judgment.
Oh, my
Just
lord.
read 3 words from the judgment and say that this is what the Supreme Court says.
No, my lord. Here, paragraph 8 says in this judgment, my lord.
It is where there is compliance, non-compliance with natural justice. In that paragraph, Karunakar judgment has been referred.
But
So
if,
therefore, we know the context in which it has been delivered. That is not a universal rule.
I bow down before
So
lordship.
therefore, now you proceed.
In this case, in this matter, my lord, initially, my lord, the matter was before the division bench, my lord. When the division bench, my lord, set aside the order of, set aside the
Division bench.
2017, my lord, another petitioner filed an application before the single bench. It was dismissed. They prepared an appeal before the division bench 2017. The division bench says that it is a fresh inquiry. Division bench set aside the order of the except charge sheet, everything was set aside, my lord. Division bench initiated, directed for a fresh inquiry. During the COVID period, my lord, the inquiry done. He says that several discrepancies during the COVID period because due to video conference that was done, and it is alleged that at the time of argument that the document used at the time of charge sheet cannot be taken up because it is a fresh inquiry. Well, there is a it is it is not a de novo, my lord. So at the time of charge sheet, there are document that he is admitting the guilt. So that document is used against him at the time of inquiry. So it is the submission by the before the court that it cannot be used as it is a fresh inquiry. It is itself he itself admitted that he is getting the money.
Then why did you issue the charge memo? You should have issued a punishment order straight away.
Charge memo and district proceeding started and the.
So why there's no requirement? According to you, he has given an admission. He has to be punished.
Yes, it is annexed to the petition.
Then why you issued the charge memo, sir? That's what we are asking you. Why did you issue the charge memo? He had already accepted. You should have dismissed him immediately. You have created a problem for yourself.
This is the
Your
fact.
officers have created this problem for you.
This is the document available. But he is admitting the
Making unique submissions.
he is admitting the guilt, my lord. It is annexed.
Then why did you issue the charge memo? It is pre-charge memo document. Then why did you issue
After
the charge?
issuance of a
Where is the
charge-
question of issuing any charge memo? He has admitted, you should have
After
dismissed.
issuance of charge sheet, my lord, he replied that he is admitting the guilt.
Where is that? Show. What is the date of charge memo?
The date of charge sheet, my lord, 15/9/2011.
Yes, show the document where he admitted after 15/9/11.
Right.
No, no. Page 73 of the stay application.
Even this is different. Charge sheet. And written document. Well, I think take it 1 minute. Page 164, my lord. 162 is the charge sheet, and 164, my lord, it is written in Bengali, 164.
And how do you expect me to understand that?
My lord. The reply against charge.
How do you expect me to
I
understand?
can translate it before your lord.
You should have. What do you mean you can?
So, may I just indicate this was the reply in response to the earlier disciplinary proceedings. The division bench of this honorable court has set aside everything, and the division bench said that the proceeding will commence from the issuance of charge sheet. After
What is
issuance
the,
of
what
the
is the
charge
date of this reply?
sheet, my reply, that is after the order of the division bench.
What
That
is the date of this reply 164? You said it is prior to. What is the date?
This has been set aside by the division bench. In 2011, proceeding was initiated.
What is the date of this reply?
30th September 2011.
Where is the date?
Lower part, my lord. This
And what is the date of the charge memo?
15/9/2011. After 15 days, my
Give us a translated copy. Then only we can consider. Give a translated copy. Letter.
Document has been relied upon.
Call the next.
21.
Yeah, it is good. It is good.
Call the next.
Not today, sir.
23.
I am appearing on behalf of the UCO Bank.
24.
This is the
Where is your counterpart?
My lord, this is the
Where is your counterpart?
counterpart, my lord. It has been served.
The section.
Not today. You have taken a resolution today. Sorry.
My lord, can it be, my lord, day after tomorrow? My lord, tomorrow I have some difficulty. That is the reason. I am ready with the matter.
Let it be tomorrow.
Very-
If you are in difficulty, ask someone to mention.
No, my learned junior is here, my lord. She will continue with section 5. my lord.
25. Next.
26. My appeal, Mr. Kaur is reading me. I'm appealing for the private petition.
What do you want?
Okay, if minor wants.
Both sides are here. Yes.
This is an appeal. This is an appeal against refusal to challenging an interim order passed.
What has happened, the promotion procedure of the additional chief engineer in respect promotional procedure of the engineer of WBAC-TCL was challenged by my learned friend. Subsequent to that, there was an order which has been passed. We filed an application bringing in certain subsequent facts, wherein we have stated that if the interim order stays, we will face certain difficulty where the total backlog, in respect of the promotion year by year, we cannot give, and the pensionary benefits and other benefits also we cannot give. That we filed by way of an application which was being rejected by Justice Chandra. We have come up before your lordship. We kindly take up the impugned order, that is at page 101. It's just a 2-page order, modification is sort of this court's order dated 22nd December 2023. It is submitted by Mr. Kaur for the applicant WBAC-TCL that in terms of paragraph 10 of the said order, the person concerned have been promoted on a temporary basis. I will show your lordship the order dated 22nd December. On temporary basis, subject to the final result of the writ petition. Since 1 year has elapsed, the employer is to take a decision on their confirmation. This court is of the view that such prayer may be made before the regular bench in terms of the order, my lord. This is the order which has been passed by Justice Mantha. May I, my lord, then the impugned order from 104 onwards, my lord. The affidavit in opposition filed by the respondent number 3 to 9 is hereby taken on record. The following interim orders have been passed in.
What happened after the Puja holidays?
After the Puja holidays, we have tried, for listing of this matter, it was not. That is the reason.
It has not come up.
No,
Still pending, my lord.
There
is one.
Today, this determination is before which bench?
Mr. Kaur is leading.
bench
One is before Justice Kapoor, there we have just finished.
That is another. My lord, I am telling you, I have
I'm asking you where this matter is supposed to be considered now.
Justice Amrita Singh. Justice Amrita
So you didn't try to get it expedited. There is a direction that it will be expedited after the Puja holidays.
But the problem is that very difficult to have a hearing matter listed. That's the main problem.
So this is admitted. This was admitted.
Admitted directions for filing affidavits were filed.
Affidavits have been.
And this is the only matter where there was an interim order.
No, I'm just trying to understand before you proceed. There is no day fixed for hearing matter. No, we do that, but we also have
There is
day for hearing of old matters.
Yes.
On Thursday we hear.
I have a very fundamental objection. The employees have not challenged who are supposed to be suffering the interim order. The WBSC-DCL has. May I just give a small background of the dispute? Dispute is that
they have a fair idea after going through the order what is going on.
75% mark has been a lot of, and my challenge has been limited to that. 75%, whether it can be done or not.
See, if we, at least the second last paragraph at page 2 of the impugned order.
Yes. Yes. Yes.
To that extent, prima facie, the observation appears to be correct. If it is decided, then what will remain? If everything takes effect, then what will remain?
There were two prayers. If your lordship looks at my application once, there were two prayers. Lord, the interim order was that they should be, Lord, promoted, but it would be on probation and on a tentative basis, without subject to the outcome of the writ petition. Now, Lord, this probation period under the rules is for a period of 1 year. And this is the post of additional chief engineer, the second highest post in the cadre. Now, Lord, post 1 year, unless they are confirmed, there are certain benefits, Lord, which they are supposed to get, the incremental benefits, which they don't get unless it is confirmed. So, Lord, the prayer was that we will confirm them subject to the outcome of the writ petition. That is the prayer made. So, Lord, it's not that, Lord, the entire writ petition would get disposed of if this protection is given. This is the only prayer, Lord, which was made before
the problem is, Mr. Kar, that you cannot give an undertaking on their behalf that they will not claim any equities.
They are parties. They are parties. Your lordships can extract that undertaking from him. I am an employer.
If they are willing to say that, yes, we accept everything will be subject to result of the writ petition.
We'll serve them a notice and come.
No, but this offer was made by the learned court.
Let us see. It's never too late.
It's never. My learned friend is there. I'm sorry.
You are for the beneficiaries.
My lord,
Promotees.
Mr. Shomo Majumdar. My lord, kindly let us.
Take an instruction on this and we'll consider. When to have it, you tell us.
My lord, kindly grants me 2 days time.
All right.
The Honorable Court had said that every, if the writ petitioner succeed, you'll have to pay back everything.
No.
This
How
was
is it your concern whether they pay back or they don't pay back? That's not your concern.
But I am.
You are concerned with that. If there is if you are found entitled to a relief, you must get it.
No, I am saying
whether they pay back or not. They have worked on the higher post. Why they should pay back?
Look, I am just bringing to your notice. This is what the court said. I did not say. The court said this. And get them time to take instructions. Then they came back. We will not.
Understand. So therefore, we are saying if they say that we will not claim any equities whatsoever subject to result, then your right will also be protected.
Yes,
they will also be able to take work from them as per their requirement. But they're subject to whatever stand they may take. If they come out with this, we don't know.
Yes.
We'll hear you on that also. But right now, let us see if they are willing or not. Yes.